Tonight, flashback to the year 2009, the year of the Grand Coalition government. James Orengo, the then Minister for Lands, says the government will demolish UK Centre since it was built on top of a tributary that drains into the Nairobi River. Also earmarked for demolition then was the Oshwal Centre and others. But things happened and all these noise generated by the looming demolition died down. Fast forward to 9 years later, the chicken have come home to roost. This time round, the UK Centre and Oshwal Centre are not being spared in the ongoing demolition of structures erected on riparian land. A testament that the intentions to bring the buildings down in 2009 were not driven by ill will. But when did the clamour for riparian land...
Receiving so many calls that, you know, how can you just sit there and watch all this destruction going on? You must stop it.
Even proposes rather changing of the course of rivers instead of demolishing houses built on top of rivers and the riparian land in the city. A very interesting observation there. So tonight on the show, I have former town clerk, Nairobi town clerk, that is Philip Kisia, and the chair of Land Development and Governance Institute, Ibrahim Odani, is also going to join us shortly. But before we hear from these two individuals, let me now cross over to our lead reporter, Sophia Wanuna, who
in Nairobi. We see what's going to be happening also at the Visual Center. We saw Dandora as well, demolitions earlier today. We've seen Kibra happening, and many more are slated to take place. And so, of course, the president talking about people who deem themselves manied, connected, trying to intervene and get also intervention from him, and having calls come through him to get this to stop, but that hasn't worked. And he said it's impossible to stop this at this particular point, maintaining that it has to continue. Due process has to take place no matter the consequences or implications. But also important and interesting, as you mentioned there, Yusuf, as well, the ones that are executing this particular arrest. And the governor has sent out a statement, that's Nairobi County, saying that due process will be followed despite this leaked phone calls, that they're on track in as far as ensuring due process and the law is upheld. But tonight, to get some perspective, because there's been numerous concerns around the due process and the law. You remember when the South End Mall was being demolished, and we covered that live, and the lawyer representing the owner of that particular building said they had all the documentation and approvals to have that mall standing, and even in fact to stop the demolition exercise, but that went on. So many legal questions around this, and tonight I get to speak to the president of the Law Society of Kenya, that's Alan Gishuhi. Thank you so much for making time for us. You have been following what's happening, and the biggest concern is on due process, so that on South End Mall, there was their lawyer saying we have all the requisite documentation. There's even orders stopping the demolition. Why is it going on? UK Mall, the same scenario. What do you make of the law and what the government is painting to be what we are doing is for public good?
Thank you, Sophie. Now, it is not such a simple matter as one would imagine that once you have a title, you have an indefeasible title. Mm-hmm. Firstly, when you go to the Constitution under Article 60, it does recognize the sanctity of title, but also recognizes at the same time some of the environmental factors like right to water, riparian mm-hmm. rights, things like that. And then we go to Article 40 that also protects and elaborates on the sanctity of title. Mm-hmm. But then Article 46 makes it very clear that land that has been unlawfully acquired shall not enjoy such protection. Now, the question that then comes to mind is, who declares that such land is unlawfully acquired? Mm-hmm. That, of course, will have to be the preserve of the court. And courts have actually said that it's until you go to court and declare that title as invalid, then you will not enjoy any protection. Mm-hmm. But then the other thing that we must appreciate is that every 30 meters from the tidal watermark, mm-hmm. then in 1998, we got the physical planning subdivision regulations that reduced that to 10 meters. And then in 2006, we get the Environmental Management Coordination Water Quality Regulations that further reduce that riparian right to 6 meters. Wow. So now, under the law, the water quality regulations actually are under the Act, and the Act says it shall be dominant regardless of any previous legislation that was passed. So as we speak now, we have to look at the aspect of what happens in such situations where you have an owner who has a lawful title subject to overriding interests, subject to riparian rights, which in the past may not have been there. And now you've got a new act that comes in 2006 and limits it to 6 meters. Now, the concern, of course, of most Kenyans is that we have the regeneration committee that has been established. We hear rumors, and I say rumors because we're not aware of any Gazette notice highlighting, I hear, 4,000 properties that have been earmarked for demolition all over Nairobi. Now, first and foremost, under Article 35 of the Constitution, it's incumbent where property rights are going to be affected for the public to be made aware of which buildings have been earmarked. And the reason is very clear. Most of these buildings happen to be commercial buildings that have tenants. And these tenants also have rights. They would also require due notice. If the building is earmarked for demolition and the planning permission was unlawfully acquired, there's a process behind it where you'll be given notice to physically demolish and obey whatever commands the notice requires you to. But then we need due process in the sense that if the building is going to be demolished, Article 47 of the Constitution also requires fair administrative action.
Okay. All right, because what we are seeing now is the demolitions are ongoing, and a lot of these people are coming out to complain and say still due process has not been followed. So in your view, what does that leave in terms of a situation for the government in damages or repaying these individuals?
Yeah, now, as I said, this evaluation really will have to be determined by the courts. There are instances where the government is absolutely right, and they will have excellent defenses to any claims if they can prove that whatever planning permissions you got were unlawfully acquired in the first instance, and the Constitution recognizes that you would not benefit from unlawfully acquired interest in land. But if, on the other hand, the court determines that your planning permissions were valid and that everything was done in accordance with the law, then of course this will be treated as a case of compulsory acquisition, where the government then will have to face damages for compulsory acquisition and loss of future profit. But it all depends with an evaluation of the evidence and compliance with the various statutory provisions. That's why it is not right to say that outright the government would face damages or not. It all depends on a case by. If a matter is pending in court and you probably even have a court order protecting your right to property, then of course that will invite contempt of court and may also invite definitely damages, depending with the circumstances of the case. But ultimately, as I said, it will have to go to full trial to determine the lawful nature of getting those planning permissions. That's the most crucial thing. Another thing that we must also be aware of is, for example, public land, roads, or any government land which has been unlawfully occupied, say by squatters. Now, do the squatters acquire any right of the land, government land? Absolutely not. What the law was amended recently, the Land Act, was that under Section 152, it made it very clear that squatters will not acquire rights over any public land or any roads if that's constructed. However, the law appreciates one thing, that you must be treated with human dignity. You must be given sufficient time for you to vacate. So what the government is required under the law to have given such instances of unlawful occupation, unlawful occupants, is 3 months' notice. Upon the expiry of the 3 months' notice, then the government can come in and move and demolish whatever structure you have there. But you must have notice. The same applies to the 4,000 or so properties. The sad thing is that there's so many people who've been affected. Now, a rough estimate would mean that the 4,000 properties that are earmarked according to, let's assume that it's 4,000 properties.
Right.
You've got the rights of the owners, you've got the rights of the tenants, you've got the rights of financiers. Now, for argument's sake, if half of these properties had lawful permission, then of course the claim for damages will be horrendously high. We're talking about tens of billions of shillings. Because what happens to the interests? What happens to the ripple effect of the economy? What happens to the issue of sanctity of title if it turns out that these properties were lawfully acquired?
Right.
So it is actually a very interesting Pandora's box that's going to happen and unfold in the next couple of months as exercise proceeds.
Let me ask you this. For Mau, for instance, there are those with title deeds.
Yes.
The CS Environment came out the other day to say there will not be any compensation even for those with titles. Of course, there are those who do not have. So how does that play out? Because the ones with titles will say we have title deeds, we own this land, but the government will be, at the end of the day, this is what this land was. Just like we saw with Kibra, they were told this was previously earlier on earmarked for construction as far as road, but those some will say we have titles. So compensation question.
Now, as I said, that there's a caveat in Article 46. If you acquire the land unlawfully, you get no compensation. I'll give an example. Even before the Constitution was passed, and there was the old Government Land Act that was repealed. Before government land could be degazetted, the whole process of degazetment was unconstitutional or illegal. So therefore, you're not entitled to compensation. Really, it would be the court to determine that.
Yeah, and are you satisfied in as far as holding to account the government officials? Because these titles are coming from government officials. We saw in the instance of the Solai Dam, the NEMO officials, some of them being charged. But we're not seeing as many of them, and yet there's so many demolitions taking place. But we would imagine there'd be...
Police to investigate how these permissions were granted and to give a report after every 21 days. We'll be very keen to have a look at that report because... the impact is devastating to the investors who are innocent. For example, I could have bought land, got permission, sold it to a third party. The party has done a due diligence such. We follow all the processes in conveyancing, and we find out that everything has been done lawfully, only to discover maybe 15 years later that the permission was unlawful at that point in time. So it's really an unfortunate situation. And I think it's also... it's a wake-up call to ensure that equity and justice actually prevails in future. So we support the lawful process, but we also demand that there should be due process at the same time, so that Kenyans should really know what is the state and what is the fate of my occupancy in a particular building. Should I be of interest is also this. Was there a study carried out to actually report and state whether the report, and the matter even went to court, and the Dungo report the courts have even held were opinions, recommendations, but did not have any binding force of law. Then the Constitution created the National Land Commission, and the National Land Commission was mandated to investigate all these titles that may have been legally acquired within 5 years. So they did that, and they applied for an extension for another term of 5 years. I don't think that was granted. Whatever extension was given was to look into historical injustices, but then that one doesn't have the force of law as the original mandate under Section 14 of the National Land Commission that gave them that 5 years to consider the validity of such titles. So it was there in the Constitution. As to how many titles have been affected, many titles were actually revoked through that. Many titles actually ended up, many people, citizens ended up in court. But the process is actually enshrined in the Constitution as far as the Dungo report was concerned, because that's where the National Land Commission zeroed in based on the Dungo report. So
if they were adhered to, would things be different, yes or no?
Yeah, of course things would be different. And we wouldn't be in the situation we are in today.
All right. Many thanks, Mr. President of the Law Society of Kenya, Alan Gishuhi, with us tonight, Yusuf.
Thank you very much, Sophia, for that. And I'm going to engage our guest in studio shortly. But before that, a report from the government, of course, indicate that they've earmarked about 4,000 buildings set to be demolished. This is a building that are on riparian land. And already several of them have been demolished. Among them, the South End Mall along Langata Road, then there's UK Centre and other buildings in Kileleshwa. These are buildings that are, worth billions of shillings. So the big question tonight is what next for the so-called Nairobi regeneration plan? In studio, I have former Town Club, Philip Kisia, and hopefully we're going to link up by way of phone to Nairobi Governor, that is Mike Mbuvi Sonko, is going to tell us more on what plans have been put in place in this regeneration, Nairobi regeneration exercise. But first, Philip Kisia, good evening. Welcome to the program.
Good evening, Yusuf, and thank you.
You're welcome. So let me take you back to 2009. This is something that we had in our intro earlier. By then, the Lands Cabinet Secretary, the Lands Minister James Orengo, said that, UK Centre should be demolished. He also talked about several other malls in Kileleshwa, Westlands, as well as Runda. That did not happen then. It happened now 9 years later, and we're seeing some of these malls being demolished now. So the big question is, why didn't it happen? Why didn't this demolition happen, for example, under your watch when you were at the helm of Nairobi County?
Now, thank you, Yusuf. First of all, I think you are being unfair by talking about demolition. We should not be talking about demolition. We should be talking about creating order and discipline. Because that is what has been lacking in Kenya. That is what has been lacking, particularly in the city of Nairobi from the late 80s. So the urban decay did not start yesterday. It started in the mid-80s. And now it has caught up with us. So demolition is just the end result of the misbehavior, the misculture that has happened over a period of time. So really, Yusuf, if you ask me, let's talk about creating discipline and order, which the President of the Republic of Kenya is trying to instill in this republic of ours. So the question that you asked was, why didn't it happen? Let's not talk about 2009. Let's start about the 80s when we started experiencing urban decay. There was lack of political goodwill. That those people who were in leadership at that particular time never gave this exercise any thought. They were not really bothered. The second thing is, of course, the issue of corruption. That there's evidence that those who are given an opportunity to provide leadership at that particular time never really bothered about law, order, and discipline. So really, it's about lacking political goodwill. There was no goodwill.
Yes,
period.
Yes, I appreciate your point of view there, and from your point of view, it seems that this is a historical problem. Let's talk about what is happening at the moment. There's the Nairobi Regeneration Plan. I believe the committee was appointed by the President in December last year, but it's only this month that we have started, seeing or, understanding what exactly they're doing with regards to the demolition and bringing sanity back to the capital. Do you think there's a plan to start with? Because, we're not seeing any kind of structures or, well-executed, public plan, something that can be put in public, and then they're going to tell us perhaps how many buildings they're targeting, when they're going to demolish it. So in a nutshell, do you think there's a proper plan in this regeneration program?
Well, I would say that, for you to undertake such an exercise, there must be a plan. I think the challenge here is that those who have been given responsibility have probably not shared that particular plan with the public. I think they probably should have been, there was need, and there's need for them to have shared that a plan they had. I'm assuming that before they started this particular exercise, that they carried out a very comprehensive audit to establish which particular buildings have been built on public space, which buildings are interfering with the flow of our reserves, and so on and so forth. So those buildings should have been the first category to be brought down. The second category, in my view, would have been probably buildings that have been put up, but without the necessary approvals. Though that is a problem that can be cured, and probably those are some of the structures that can be spared, because it's an issue of professionals coming, looking at the issue, and giving them necessary approvals. Then there is the other one, the third category probably is a category that there are buildings which have been put up and something can be done to save these particular buildings. So in my view, the report should have been more structured, shared with the public, and then we as a public agree on a way forward. I heard the president of LSK talk about notices. I'm sure that these people have been given notices. When I was in office from 2009 for 3 years, the same buildings were given notices, but most of these people, of course, run to courts. They get injunctions and you're unable to move.
So that explains basically why the process took this long up to 2018.
Yeah.
But of course, speaking about approvals, those who are saying they have the relevant papers, they have the title deeds, we're going to probe that even further within the program. But for now, let me take a very short break, but we'll be coming up shortly. Stay with us. We're still